Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Hey everybody, this is me. I am getting myself into bed, but I wanted to bring to you guys the filing that happened for Mr. Kelly, and I was supposed to do it earlier, but I just forgotten, and I was like, oh man, let me go ahead on and do this. So I'm gonna let this reader read it for you guys. I hope I did it right. So it's supposed to be option escape.
No. In the Supreme Court of the United States, Robert Sylvester Kelly, petitioner, v. United States of America, respondent, on petition for writ of certiorari to the United States Court of Appeals for the Seventh Circuit, petition for writ of certiorari, d. Jennifer Bongian, Counsel of Record, Bongian Law Group PLLC, 303 Van Brunt Street, Brooklyn, New York 11231, 718-875-1850, Jennifer@bonjeanlaw.com. Counsel for petitioner, I. Question presented, consistent with the presumption against retroactive legislation, whether the 2003 amendment to 18 U.S.C. Section 3283, which extended the statute of limitations for sex offenses against children, was inapplicable to charged conduct from the 1990s, such that defendants' charges were brought outside the applicable statute of limitations. 2. Table of contents, page. Question presented, I. Table of authorities, I've. Opinions below. 1. Statement of jurisdiction. 1. Statutory provisions involved. 1. Statement of the case. 2. A. Evidence related to Jane. 3. B. Evidence related to Nia. 5. See evidence related to Pauline. 6. Argument. 8. Because Congress did not express an intent for the Protect ACT to apply retroactively, defendants' charges for conduct committed in the 1990s was time-barred. 8. Conclusion. 16. 3. Appendix Table of Contents. Appendix A. Opinion of the United States Court of Appeals for the Seventh Circuit, dated April 26, 2024. 1. Appendix B. Judgment of the United States District Court for the Northern District of Illinois, dated March 7, 2023, 16. Appendix C. Order denying severance and motion to dismiss of the United States District Court for the Northern District of Illinois, dated June 30, 2022, 33. Appendix D, statutory provisions involved. 18 U.S.C. Section 3283, 44a, IV. Table of Authorities, pages, cases, Appalachian Power Company v. EPA, 249 F3D 1032, DC 2001. 12. Food and Drug Admin, v. Brown Ann. Williamson Tobacco Corp., 529 U.S. 122,000. 13. Landgraf v. USI Film Products, 511 U.S. 244 1994. 8, 11, 12. Ladab v. Ashcroft, 384 F3D8, First Ser, 2004. 13. Martin v. Haddix, 527 U.S. 343, 1999. 13. Martin v. Hunter's Lessee, 14 U.S. 304, 1816.
What the heck? Why stop, y'all? Why stop?
(14 U.S. 304, 1816). 12. Order of our Telegraphers v. Railway Express, Agency Incorporated, 321 U.S. 342, 1944. 9. Salahuddin v. Mean, 174 F3D 271, 2D Ser, 1999. 12. Stodner v. California, 539 U.S. 607, 2003. 14. Tausi v. United States, 397 U.S. 112, 1970. 8, 11, 14, 15. United States v. Deal, 775 F3D 714, 5th Ser, 2015. 10. V. Pages, United States v. Gentile, 235 F. Sup, 3D 649, DNJ 2017. 14. United States v. Miller, 911 F3D 638, First Ser, 2018. 14, 15. United States v. Rivera Ventura, 72 F3D 277, 2D Ser, 1995. 15. Velasquez Garcia v. Holder, 760 F3D 571, 7th Ser, 2014. 11. Statutes, 18 U.S.C. Section 2251, 2. 18 U.S.C. Section 2252a, 2. 18 U.S.C. Section 2422b, 2. 18 U.S.C. Section 3282, 9. 18 U.S.C. Section 3283, 2024. 1, 2, 8, 9, 10, 11, 12, 15. 18 U.S.C. Section 3742. 1. 28 U.S.C. Section 1254 1. 1. 28 U.S.C. Section 1291. 1. Child Abduction Prevention Act, H.R. 1104, 108th Cong. Section 202, 2003. 13. Protect Act, S. 151, 108th Cong. 2003. 9. 13. Constitutional Provisions, U.S. Const. Amend 6. 9. U.S. Const. Art. I. Section 10, CL. 1. Ex post facto clause, 8, 14, 15. 1. Opinions below. The opinion of the United States Court of Appeals for the 7th Circuit is reported at United States v. Kelly 99 F. 4th 1018, 7th Ser, 2024. App. A. Unofficial reports to the opinion can be found at 2024 U.S. App. Lexus 10133 and 2024 WL 1814054. The order of the United States District Court for the Northern District of Illinois is not reported. United States v. Kelly, number 19 CR 567, NDL June 30, 2022. App. C. Statement of Jurisdiction. The District Court for the Northern District of Illinois entered judgment against the defendant on March 7, 2023. App. B. A timely notice of appeal was filed on March 9, 2023. The jurisdiction of the United States Court of Appeals for the 7th Circuit was founded upon 28 U.S.C. Section 1291 and 18 U.S.C. Section 3742. The Court of Appeals for the Seventh Circuit entered its judgment on April 26, 2024. This petition for writ of certiorari is being filed within 90 days of the Seventh Circuit's opinion, Sup. Court, R13-1. This court's jurisdiction is invoked under 28 U.S.C. Section 1254-1. Statutory provisions involved. 18 U.S.C. Section 3283, 2024. No statute of limitations that would otherwise preclude prosecution for an offense involving the sexual or physical abuse or kidnapping of a child under the age of 18 years shall preclude such prosecution during 2. The life of the child, or for 10 years after the offense, whichever is longer. 18 U.S.C. Section 3283, 2003. No statute of limitations that would otherwise preclude prosecution for an offense involving the sexual or physical abuse of a child under the age of 18 years shall preclude such prosecution before the child reaches the age of 25 years. 18 U.S.C. Section 3283, 1994. No person shall be prosecuted, tried, or punished for any violation of the customs, laws, or the slave trade laws of the United States unless the indictment is found or the information is instituted within 5 years next after the commission of the offense. Statement of the case. On February 13, 2020, the government filed a 13-count superseding indictment charging defendant Kelly with 4 counts of violating 18 U.S.C. Section 2251, the child pornography counts, 1 count of conspiracy to obstruct justice in connection with his 2008 state court acquittal, 3 counts of violating 18 U.S.C. Section 2252, related to receiving the aforementioned child pornography, and 5 counts of violating 18 U.S.C. Section 2422b. The inducement counts. Kelly's co-defendants were charged in connection with obstruction of justice and receipt of child pornography. After a 4-week jury trial, the jury returned a guilty verdict against defendant as to 3 of the child pornography counts and 3 inducement counts. Defendant was acquitted as to the remaining 3 counts. His co-defendants were acquitted of all counts. The charges for which defendant was convicted, counts 1 through 3 and 9, related primarily to minor 1 who used the pseudonym Jane at trial. 1 inducement count, count 10, related to minor 3, who used the pseudonym Nia at trial, and 1 inducement count, count 12, related to minor 5, who used the pseudonym Pauline at trial. The superseding indictment in the case largely charged defendant with conduct from the mid to late 1990s. Prior to trial, defendant moved to dismiss all counts related to sexual exploitation of a child on statute of limitations grounds. The district court denied the motion. Evidence related to Jane. Jane testified that she was born in September 1984 and was raised in Oak Park, Illinois. When Jane was a junior in high school, she started being home-schooled because she was performing in a musical group with other members of her family. Her entire family was involved in the music industry. Jane was introduced to the defendant through her Aunt Stephanie Sparkle, who was a singer who had collaborated with the defendant. The defendant and Sparkle also had a romantic relationship. When Jane was 13 or 14 years old, she would hang out at the defendant's recording studio with her aunt. Jane explained that she would go to the studio and watch defendant record with her aunt, and it was nice to see them working and producing music. Sparkle began encouraging Jane to foster a closer relationship with the defendant. R726. 4. According to Jane, Sparkle told her to ask defendant to be her godfather and instructed her to sit on his lap and rub his head. Jane wanted to have a closer relationship with the defendant and did what her aunt advised, asking defendant to be her godfather. The defendant agreed. Jane told her parents that the defendant agreed to be her godfather, and they were pleased. Jane testified that her relationship and conversations with the defendant began to change, becoming more sexual and leading to phone sex. When Jane was 14, she and the defendant began to engage in sexual contact. The sexual contact involved touching and rubbing each other's genitalia, oral sex, and kissing and hugging. These occasions were frequent and occurred at defendant's studio, his home, and on his tour bus. Jane's parents allowed her to stay with the defendant, including overnight. After Jane turned 15, she and the defendant started to have sexual intercourse. Defendant started video recording his sexual activities with Jane when she was 14 years old. Jane testified that prior to taking the stand, she viewed video footage of 3 separate sexual encounters with the defendant. One occurred in the living room of his home, one occurred in his bedroom, and one occurred in a room referred to as the log cabin room. In defendant's home, the videos depicted touching and oral sex, but did not involve sexual intercourse. Jane testified that she was 14 years old in all 3 videos that she identified. The 3 videos were introduced into evidence as government's Exhibits 1 and 2. One of the videos was captured on Government's Exhibit 1 and the 2 of the videos were captured on Government's Exhibit 2. The 5 videos form the basis of counts 1 through 3 of the superseding indictment. The evidence related to Nia. Nia testified that she met defendant in a shopping mall in Atlanta in 1996 when she was 15 years old. Nia was born in August of 1980. Nia obtained an autograph from the defendant on which he allegedly wrote down his phone number. Nia admitted that she did not discuss her age with the defendant, and she no longer had the autograph he gave her. Nia testified that the defendant asked her if she was going to his concert in Atlanta that evening. When she told the defendant she did not have tickets, defendant arranged for her to obtain tickets. Nia did not attend the defendant's concert but began calling the defendant that evening. Nia explained that she had several conversations with the defendant and that she liked him. According to Nia, the defendant arranged for her to travel to Minnesota to attend his concert. Nia attended the defendant's concert but did not see him until the following morning in her hotel room. Nia testified that defendant kissed her, touched and kissed her breasts, and then masturbated. Defendant told her that he wanted her to visit him in Chicago. Defendant did not follow up on the invitation and did not book any arrangements for Nia to come to Chicago. However, Nia made her own arrangements and went to stay with family in Chicago the summer of 1996, unbeknownst to the defendant. Once in Chicago, Nia called the defendant. He invited her to his studio but made no arrangements for her to come there. Nia convinced her cousins to take her to the studio. 6. Nia arrived at the studio with her cousins and defendant showed them around and took them to a waiting area where they could see him record. Nia and her cousin stayed most of the evening, but defendant was recording and was not hanging out with Nia and her cousins for most of the evening. At some point, Nia was told defendant wanted to talk to her in the hallway, and Nia went into the hallway to see him. Nia testified, he greeted me with a hug, with a kiss, and held on to her for a moment and they kind of made out a little. Nia elaborated, I remember his hand being around my waist on my bottom, my butt, and then he motioned his hands into my pants as we kissed, and he fondled my chest. And he, kissed. We just kind of made out within the time frame that we were in the hallway. Nia stated, he touched my vagina and he caressed my bottom, my behind. Nia testified that before she left, she had a second encounter with defendant. She stated they embraced, hugged, he held on to me, held my bottom, and things of that nature, but it wasn't as long as the first on. It was more of like kind of, like a goodbye, see you later. Nia never saw or spoke to the defendant again, but in 2002, Nia sued the defendant, and the case settled for $500,000. The evidence related to Pauline. Pauline testified that she was born in October 1984 and grew up in Oak Park, Illinois with Jane. Pauline and Jane became friends in middle school. Pauline met the defendant through Jane when she was 14 years. Pauline explained that when she was 14 or 15 years old, she discovered Jane and the defendant in the log cabin room. Jane was naked. 7. Pauline testified that she had her first sexual encounter with the defendant when she was 14. She began having sexual encounters with both the defendant and Jane, which included oral sex. Pauline eventually began having sexual intercourse with the defendant when she was around 15 or 16. When Jane discovered Pauline was having a separate sexual relationship with defendant, it became very problematic for their friendship. Pauline admitted that she continued to have a sexual relationship with the defendant until she was grown and was out of college. Pauline did not report to any authorities that she had a sexual relationship with the defendant when she was a minor until 2019. The government presented lengthy excerpts of the video recordings depicting defendant's sexual conduct with Jane on 3 separate occasions. Much of the government's case centered on the defendant's alleged efforts to obstruct the state court prosecution of defendant in connection with one of the videos depicting his sexual conduct with Jane in 2008. The jury acquitted all defendants of the obstruction of justice count and all counts related to the receipt of child pornography. The jury also acquitted defendant of 2 inducement counts related to Tracy Ann Brittany. The jury returned a verdict of guilty against the defendant in connection with the child pornography counts involving Jane, counts 1 through 3, the inducement count as to Jane, count 9, and 2 additional inducement counts in connection with Nia and Pauline, counts 10 and 12. Defendants' post-trial motions were subsequently denied. The district court judge sentenced the 8 defendant to 240 months imprisonment. Judgment was entered on March 7, 2023. Defendant's convictions and sentence were affirmed by the United States Court of Appeals for the 7th Circuit. The 7th Circuit rejected defendant's argument that his charges were barred by the applicable statute of limitations. United States v. Kelly, 99 F. 4th, 1018, 7th Ser. 2024. App. A. 5 and 9. Argument, because Congress did not express an intent for the Protect ACT to apply retroactively, defendants' charges for conduct committed in the 1990s was time-barred, in contrast with this court's decision in Taussig v. United States, 397, U.S. 112, 115, 1970, and Landgraf v. USI Film Products, 511, U.S. 244, 265, 1994. The 7th Circuit sanctioned the retroactive application of the 2003 amendment to 18 U.S.C. Section 3283, the PROTECT Act, which extended the statute of limitations for child sex offenses, reasoning that its application did not offend the ex post facto clause. This court should grant review to reaffirm the long-standing principles that criminal limitations are to be liberally interpreted in favor of repose and that legislation is presumed to apply prospectively, regardless of ex post facto considerations unless Congress expressly states otherwise. This court should clarify that Landgraf provides broader protections for criminal defendants than the ex post facto clause because criminal statutes of limitations are designed to protect individuals from 9. Having to defend themselves against charges supported by facts that are remote in time. Statutes of limitations are designed to promote justice by preventing surprises through the revival of claims that have been allowed to slumber until evidence has been lost, memories have faded, and witnesses have disappeared. Order of our Telegraphers v. Railway Express Agency, Incorporated, 321 U.S. 342, 348, 1944. 2. Allow Congress to continue to extend criminal statutes of limitations so as to abolish them altogether interferes with the defendant's ability to fairly defend against ancient conduct in violation of the Sixth Amendment and due process clauses, even if a defendant's ex post facto rights have technically been preserved, because Congress did not expressly state that the PROTECT Act should apply retroactivity, and even rejected a version of the bill that include a retroactive provision. The PROTECT Act did not extend the statute of limitations and defendant was convicted of time-barred offenses. Federal law imposes a 5-year limitations period for most non-capital offenses. 18 U.S.C. Section 3282. Over the years, Congress has provided a longer limitations period for offenses involving the sexual or physical abuse or kidnapping of a minor. 18 U.S.C. Section 3283. At the time defendant committed the conduct for which he was charged and convicted, namely the child pornography counts 1 through 3, and the inducement counts 9, 10, and 12. Section 3283 provided as follows: no statute of limitations that would otherwise preclude prosecution for an offense involving the sexual or physical abuse of a child under the age of 18 years shall preclude such prosecution before the child 10 reaches the age of 25 years. 18 U.S.C. Section 3283, 1994, App. D. Consistent with the foregoing provision, at the time of the charged conduct, the statute of limitations for offenses involving sexual abuse were extended until the victim minor reached 25 years old. Thus, Section 3283 extended the 5-year limitations period for the conduct alleged in counts 1 through 3 and 9 of the superseding indictment until September 2009, when Jane reached her 25th birthday. The statute of limitations for count 10 was extended until 2005, when Nia turned 25 years old, and the statute of limitations for count 12 was extended until October 2009, when Pauline turned 25 years old. Defendant was not charged until more than a decade after the expiration of the statute of limitations under the applicable law at the time of the alleged conduct, unless subsequent amendments to Section 3283 apply retroactively. In this case, defendant's charges were time-barred. In 2003, Congress amended the statute, extending the statute of limitations through the life of a minor. 18 U.S.C. Section 3283, 2003.1. Congress did not express an intent for the 2003 amendment to apply retroactively. Consistent with the well-established presumption against retroactive legislation, the 2003 amendment is inapplicable to the charged conduct, as is any subsequent amendments to Section 3283. C. United States v. Deal 775, F3D 714, 720, 5th Ser. 2015, applying the version of 18 U.S.C. Section 3283 inches. Effect at the time of the defendant's offense. 1. Congress amended the statute again in 2006 to its current version, which provides a limitations period for the life of the victim or 10 years after the offense, whichever is longer. 18. U.S.C. Section 3283. 11. Then the amended version in effect at the time of the indictment. It is axiomatic that criminal limitation statutes are to be liberally interpreted in favor of repose. Talley v. United States 397, U.S. 112, 115, 1970. Our retroactivity is not favored in the law. Velasquez Garcia v. Holder 760 F3D 571, 579, 7th Ser. 2014. Quoting Bowen v. Georgetown University. Hosp. 488, U.S. S. 204, 208, 1988. This court has explained that the aversion to retroactive rulemaking is deeply rooted in our jurisprudence and embodies a legal doctrine centuries older than our republic. Elementary considerations of fairness dictate that individuals should have an opportunity to know what the law is and to conform their conduct accordingly. Settled expectation should not be lightly disrupted. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal human appeal. Landgraf v. USI Film Products 511, U.S. 244, 265, 1994. With these principles in mind, the Seventh Circuit erred when it retroactively applied the 2003 or 2006 versions of Section 3283 and denied defendants' motion to dismiss on statute of limitations grounds. This court's decision in Landgraf set forth a framework for determining whether a federal statute of limitations applies to past conduct. The court's first task is to determine whether Congress has expressly prescribed the statute's proper reach. If Congress has done so, of course, there is no need to resort to judicial default rules. When, however, the statute contains no such express command, the court must determine whether the new 12 statute would have retroactive effect, i.e., whether it would impair rights a party possessed when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions already completed. If the statute would operate retroactively, our traditional presumption teaches that it does not govern absent clear congressional intent favoring such a result. Idea 280. Thus, under Landgraf, if Congress has expressly prescribed that a statute applies retroactively or will not apply retroactively, the inquiry ends. If the statute is silent on the issue, courts proceed to the second step of the Landgraf analysis and determine whether the new statute would have retroactive effects. ID. Here, the 2003 amendment of Section 3283 contains No language expressly prescribing retroactive application of the amendment, although the statute does not expressly provide that it may only apply prospectively. It employs language that points toward prospective application. The section twice uses forward-looking modal verbs, would and shall. 18. USC Section 3283. No statute of limitations that would otherwise preclude prosecution for an offense involving the sexual or physical abuse or kidnapping of a child under the age of 18 years shall preclude. Doc. See Appalachian Power Company VPA 249 F3D 1032, 1057, DC 2001 characterizing the phrase would omit as a future conditional phrase. Salahuddin v. Mean 174 F3D 271, 275, 2D Ser. 1999. There is no doubt that shall is in imperative, but it is equally clear that it is an imperative that speaks to future conduct. Martin v. 13. Hunter's Lessee, 14 U.S. 304, 314, 1816. The word shall is a sign of the future tense. App. D. The legislative history of the statute further supports defendants' contention that Congress used prospective language in the statute to evince its intent that the statute apply prospectively and not retroactively. Critically, Congress considered an rejected language that expressly prescribed retroactive effect, showing its intent that the amendment only apply prospectively. In fact, the House of Representatives version of the bill provided for the complete elimination of a statute of limitations and included an express retroactivity provision declaring the amendments made by this section shall apply to the prosecution of any offense committed before, on, or after the date of enactment of this section. Child Abduction Prevention Act, H.R. 1104, 108th Cong. 202, 2003. The Senate version contained no retroactivity provision. Protect Act, S-151, 108th Cong. When the House and Senate conference to resolve differences between the bills, the retroactivity provision was omitted. Senator Leahy, one of the bill's original co-sponsors and a former chair of the Senate Judiciary Committee, stated on the Senate floor, the omission was intentional. I am pleased that the conference agreed to drop language from the original House-passed bill that would have extended the limitations period retroactively. Senator Leahy, Amber Legislation, Cong. Rec. 149 hours and 50 minutes, S. 5147, 2003. The legislative history of the bill expresses Congress's intent that the amendment apply prospectively. See Martin v. Haddix, 527, U.S. 343, 355. 57, 1999. Examining structure and legislative history as part of first land graph step. See also Food and Drug Admin. E. Brown and Williamson. Tobacco Corp. 529, U.S. 120, 144, 2000. Laddop v. 14. Ashcroft. 384 F3D8 14. First Ser. 2004. Our inquiry is not limited to the statutory text, but may include an examination of standard ensigns of statutory construction, such as the statute's truck and legislative history. In sum, Congress affirmatively rejected the proposed retroactive application provision, indicating its intent that the statute apply prospectively, even if Congress's intent is not express. Retroactive application of the 2003 amendment fails to pass the second prong of the Landgraf test. This court held in Stodner v. California, 539 U.S. 607, 618, 2003, that retroactive applications of extended statutes of limitations to revive time-barred claims violate the ex post facto clause. Admittedly, the 2003 and 2006 amendments did not revive time-barred claims in this case, but rather extended the limitations period for prosecuting those offenses before the limitations period expired. However, defendant maintains that an analysis of the retroactivity of a criminal statute of limitations under the second step must recognize the principle that unlike civil statutes of limitations, criminal limitations are to be liberally interpreted in favor of repose. Towsey, 397 U.S. at 115. See also United States v. Gentile, 235 F sub 3D 649, 655. DNJ 2017 observing that if Landgraf and Taussig are read in conjunction, courts must interpret the statute of limitations in a manner favoring repose for defendant. As the First Circuit acknowledged, Taussig potentially alters the second step in the Landgraf approach in criminal cases. United States v. Miller, 911 F3D 638, 645, Verser, 2018 evaluating 2003 amendment and adjudicating ineffective assistance of counsel claim. In other words, when Congress has sounded an uncertain trumpet, a court ought to refrain from applying an 15. Enlarged criminal statute of limitations, retrospectively, ID, as discussed, supra, Congress sounded an uncertain trumpet regarding the retroactivity of the 2003 amendment when it affirmatively removed a retroactivity provision from the bill. In light of Taussig, this court should grant review and find that a retroactive application of the 2003 amendment must be rejected even if it is not the equivalent of an ex post facto violation because it runs afoul of familiar considerations of fair notice, reasonable reliance, and settled expectations. Put differently, this court should clarify that the second step of Landgraf provides broader protections for criminal defendants than the ex post facto clause. Statutes of limitations applicable to criminal prosecutions are designed principally to protect individuals from having to defend themselves against charges supported by facts that are remote in time. United States v. Rivera-Ventura, 72, F3D 277, 281, 2D Ser, 1995. That concern was acute in this case, where the government sought to rely on the retroactive extension of criminal statute of limitations to prosecute a case based on conduct that is more than 2 decades old. Retroactive application of the 2003 amendment not only fly in the face of congressional intent, it violates notions of fundamental fairness. In sum, Section 3283 by its language and its legislative history was intended to apply prospectively. The inquiry ends there, but even if this court examined the question under Step 2 of the Landgraf analysis, it should decide against retroactive application of the amendment. This court should grant this writ to clarify and reaffirm the teachings of Taussig, namely that statutes must be presumed to apply prospectively absent clear 16 language to the contrary, and the statute should be interpreted in favor of statute of repose. Conclusion. For the foregoing reasons, defendants petition for a writ of certiorari should be granted. Respectfully submitted, Jennifer Bongian, Counsel of Record, Bongian Law Group PLLC, 303 Van Brunt Street, Brooklyn, New York 11231, 718-875-1850, Jennifer@bongianlaw.com. Counsel for Petitioner, Appendix 1.
All right, that was it, guys. This is all the appendix and stuff like that, where they got it from. Do y'all want to read this? I need to get to bed, but we can do this another time. Sounds good? Okay, good people. I just want to have this read to you guys to so you know what's going on. You know, I keep you abreast. Good night.